Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, good morning, everybody. Today, our topic is how business divorce impacts the sale of real estate. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like, subscribe to our channel. You can find us on YouTube. You can find us on Facebook. We'd love to have the follow and enjoy you being with us. With that, we're going to turn to Sean for our legal update.
So what I want to talk about today is the difference between an assignment and a novation of a contract. There are two investment strategies or disposition strategies when you have a property under contract. And they have some similarities and some differences. And so an assignment is basically where you have the property under contract and you're not going to assign the real estate because you don't own it, right? You're not a fee owner of the real estate. So you're not assigning or selling or conveying the real estate. Instead, you're assigning your purchase contract rights. So you're assigning the actual purchase contract, the right to buy or purchase the property is what you're signing. So essentially what you're doing is you're conveying a personal property interest because that contract is personal property. It's not real estate. It's a piece of paper, basically. And you're assigning it or moving it from you to somebody else for some form of fee. And then escrow closes under the original purchase contract with whoever you've assigned the contract to. So the original purchase contract still remains and stays in place. A novation is a little bit different. A novation is, by definition, a replacement contract. So when you novate, it means you've replaced one contract for another. And so in a novation, what's happening is there's this other buyer out there that wants to buy the property. But instead of taking over the existing contract, they basically go around that existing contract and contract directly with the seller. So now you have two contracts. You have the original contract, and then you have the second contract, which is between the seller and the new buyer. So what happens? How are you compensated in that scenario, right? Because in an assignment, you assign the purchase contract and you receive a fee. In a novation, you're basically being replaced. While you have a contract interest, you're being replaced. The escrow is not closing on the original contract. That's no more. It's going to be extinguished. Well, the way that the original buyer is compensated in novation is basically a release fee. So the original buyer presumably is going to record a memorandum of the contract because their contract allows for them to do it. If their contract doesn't allow, they shouldn't be recording a memorandum. But assuming the contract allows for the memorandum to be recorded, they record the memorandum. And so in order for the new buyer to be able to close, some compensation has to be paid to the original buyer to release their memorandum and to basically terminate the existing contract. And so that is how that original buyer is compensated in novation. Now, both of these involve one escrow. So that's the advantage of a novation as opposed to a double escrow where you're going to have two escrows, right? And generally you're going to have some form of transactional funding in place to close the first escrow, and then you can close on the second. Now you have, double the escrow fees and costs and title insurance versus a novation. You only have one escrow, which is the same in an assignment. You have one escrow, but the difference is that you're closing on a brand new contract in a novation, and in an assignment, you're closing on the existing contract, the original contract. So that's the difference between an assignment and a novation.
So, notwithstanding those differences, you can see why it's easy for the average real estate investor to confuse the two. And I know this isn't a show dedicated to assignments and novations. We've done those, but given that information, what transaction lends itself best to an assignment versus a novation? Why would I use one or the other?
An assignment is useful for an end buyer investor, somebody who has either the ability to obtain hard money or the ability to purchase the property in cash, and they intend to either hold it for investment purposes and lease it and things like that, or they intend to fix it up and then sell it for a profit, a quote unquote fix and flip, right? So the end buyer in an assignment is generally going to be another investor. Versus a novation, that's the end buyer. It's a better fit for an end buyer who actually intends to reside in the property and is wanting to purchase it by more conventional financing, because lenders don't generally want to fund on original contracts where the end buyer is not the original buyer in the purchase contract. They don't like that. That's not comfortable for them. That's outside of their underwriting guidelines. But they are comfortable if the contract is with the end buyer and the seller directly. So if you have this replacement contract that is in place, then they're more comfortable because the buyer in that purchase contract is going to be the actual end buyer purchasing the property. And so somebody who wants to purchase the property as their primary residence, or they want to obtain conventional financing to purchase the property, a novation's probably a better fit. So really, the determination generally of, well, do I do an assignment or do a novation, is generally going to depend upon the end buyer. Who's your end buyer going to be? Now, the importance of knowing that, or having that strategy at the beginning, though, is critical, because if you enter into just a basic purchase contract that has no novation language, no provisions for the ability to do a novation, then it may be more difficult for you to convert to a novation midstream, versus if you have that in there and say, hey, I have the opportunity potentially to novate, and have this contract terminated. You can buy me out if there's this other end buyer there.
Because you're relying on the compliance of the seller.
Correct.
This other third party to kind of play ball.
Yeah. So if you don't have that in your original contract, and then you're like, oh, well, this end buyer needs to contract directly with the seller. Now you're going back to the seller saying, hey, there's this thing called novation. This end buyer wants to contract directly with you. And, you basically have to redo the transaction, versus if you have, say, a novation addendum on the front end that talks about, the possibility of doing a novation, then you don't have to convert midstream, but you can still assign. So, even though you have this novation addendum, doesn't mean that you don't have a right to assign. So if you find an end buyer that doesn't need a separate or a contract directly with the seller, but they're just happy to close on the existing contract, then you can still assign, and it's going to be easier. Novation is a much more complicated transaction, does rely upon seller's cooperation and compliance, with the contract and agreement to execute, documents at closing, on that new contract. And so, but if you have that in there and the seller's been educated up front and they're aware of, hey, there's this novation concept out there that may apply, you're going to have a much easier go of it, if you will.
The best it sounds like that you can plan for that scenario is just required transactionally that the seller cooperate.
Yeah.
In the event that novation
That's
is the
exactly
option.
right. Yeah.
Well, I can see why that would provide a powerful kind of strategic plan for the buyer in terms of knowing what forms they're going to use, knowing what who their end transferee is going to be, so to
Right.
speak. If it's other Joe Schmo real estate investor that's got connections with hard money that they met at a marketing event, they're probably doing an assignment.
Right.
But if it's maybe some family members that they found that are really looking at their first home and are doing conventional financing, it's going to require innovation.
Correct. Yeah.
Very interesting. All right. Thank you for the legal update, Sean. Now we're going to get into our topic today. And today we're talking about how business divorce impacts the sale of real estate. We've spoken for a number of episodes about what it takes to properly uh, transact and how and what it takes to properly set up your entity, set up the real estate investment on the front end. We haven't talked a lot about what happens when things fall apart on the back end. And today we wanted to talk about specifically the idea of business divorce. And business divorce is just a legal term or a phrase that lawyers use to kind of explain the process of a breakup of a business. What happens when the partners, the business members, officers, directors of a corporation, whatever the form may be, can no longer get along, what that looks like, and how that can impact your real estate deal. Now, before we get into that, Sean, you, as an attorney, have some experience in this area. Why don't you tell our listeners a little bit about that?
Yeah. So, number of years ago, I worked at a firm in Phoenix, and I worked in the business disputes or business divorce department, and I was one of their litigators in that department. And so I saw the back end of business disputes and business divorce and what that does to the operations of the company, what that does to the owners of the company. And it's having seen the back end, it makes me appreciate the front end of business transactions and business formation much better, because I understand and see and have seen, what happens to these otherwise successful companies, if the business owners cannot get along, or they have conflict, or some other issue has come up that, you know, it's kind of a roll of the dice whether the company survives that.
Yeah. Well, we thought it was an important topic today because, what you're seeing with real estate investors are a couple different scenarios. But on one hand, one scenario is let's get together and maybe put together a joint venture agreement, get together and maybe we'll do a flip together, some other real estate investment. But in a lot of cases, we know this because we're working with a lot of them. They're forming companies. They're joining together for purposes of a partnership together as one company to do a real estate investment. And when that happens, the consequences and the fallout is different than if you were just separate contracting parties on a deal and what might happen with the real estate. So as we get into this, let's talk about on the front end the common types of business disputes that you commonly saw. And I think this is probably the case with any type of business. Doesn't have to just be real estate investment, but what are the common types of disputes that you typically saw?
Yeah, one common dispute that we saw involves money, and in particular, it's the failure of one or more of the owners to financially invest in the company. We call it, the legal term of art is capital contributions. It's failing to make your fair share of the capital contributions so that the company can get up off the ground, can operate, can maybe enter into a different area, or can expand. All of that sometimes requires an investment of capital. And so generally, there's provisions in, say, an operating agreement that states that, the members are required to invest capital at certain periods of time, initially, and then, throughout the course of the company operations. And what happens is you have certain owners that are, more well off or, financially capable, and they're putting in, and yet the other owner is not. Sometimes the owners know this going in, and because they know it going in, they say, okay, well, this other owner is going to do sweat equity, right?
Yeah, the capitalization can take different forms, not just
Right.
money, right?
Right. So they're going to do sweat equity. And so maybe what you do is you do, some capital contributions, and then maybe the other members that are more financially well off start making loans and things like that to the company. And so they're basically funding the operations of the company, while the other person is doing the quote unquote sweat equity. And maybe that person is doing a lot of the work within the company, and that's kind of their, main role or job. And where things start to break down is when, and where people start to resent the other owner is, and this is not an uncommon scenario. The other owner decides, well, I need to be paid. I need to take a salary. So they start taking a salary. Well, in addition to that, let's say that, this is an investment business. So they're like, well, I need to go to like, um, networking events and trade shows and different things. Uh, and so I'm going to, start traveling, and so the company's going to pay for my travel and pay for my, you know, uh, entry fees to these, events. And I'm going to be, basically, going to dinner and expensive dinners and this and that. But at the same time, no payments are being made to the owners that are putting in the money so that this can happen.
Right.
And so it causes a certain level of resentment to say, wait a minute, this is not the time to be doing this. And this is just commentary. I'm not saying any side is right on any of this. I'm just saying this is what happens, right? You have the people who are putting in the money, and they're like, this other owner's traveling around receiving a salary, and yet, not one dime is coming back our way. We're owed money for loans. We're owed, we want our capital returned. We want profit to be paid. I mean, why do you own a business? You own it, to receive a share of the profits, but we're not getting any profit, yet this person's being paid a salary. They're traveling around. They're having a great time, basically on our money. And that creates an issue.
Well, and as I recall, wasn't too many episodes, our episode with Why Flips Fail with Andrew Bang, one of the things that he mentioned was, or one of the red flags in some of these deals is the money, the one with the money oftentimes is passive, and the person with earning the sweat equity, and of course the idea is go earn your sweat equity, right? So go do it, go do the work. And I think a lot of folks with the money are with the money because um, maybe they've made it. They've had big investments. They don't wanna do the hard lifting. They just wanna put the money in and get the investment back out, right? So, the problem is they're the ones with the biggest amount to lose. And I think that's where it can kinda set you up on the capitalization side of things for a problem if they're not the one running the ship, the one that didn't it isn't and lends itself to a lot of questions. What other areas, I know that, um I know that beyond capitalization, another area that can be an issue will be, in terms of loans that the investor might make. Because oftentimes I'll work with, investors who will do a combination of different things and how they structure it, because some forms of money are easier to get back, some are riskier, some are a little bit safer, so sometimes they'll structure some of it as capital contributions and others as loans. Um, let's talk about, uh, disputes that arise out of loans. It's really the same kinda thing where the company, is failing to pay back the member loans, right?
Yeah. So, like you said, you can help fund the company by also providing member loans. Those are treated a little bit different because now you're not an investor in the company, you're a creditor of the company. And to me, the issue arises with member loans, um, by not having the loan documented on the front end as far as what the company's obligations are. And so you should establish a repayment schedule for those loans, and those loans should be paid before anything else. And so just as though the company is paying the salary of maybe the member that's earning the sweat equity, right? Uh, because they're working full time in the business, so you're paying them a salary, and you don't miss, there's no missing a paycheck. Um, but the next in line, the next thing that should be paid is member loans. The funds should not be, uh, and it should say, okay, X amount a month or a quarter or whatever the arrangement is. And this is an amount that's going to be paid. We're going to pay that before we, you know, do marketing events and trade shows and whatever else. I mean, that's paid first. And then next, we'll pay this and that. But the problem is loans are made, they're booked, they're on the books of the company, but then there's no repayment schedule. And so that's where the resentment comes in, which is, oh, I made this loan, it's not being repaid. But everyone else is running around having a good time on my money. And that creates problems.
The other big area and problem that I've seen with loans is the handshake deals, or write it on the back of a napkin deals, or I've seen write it out on the back of an operating agreement. And I'm like, well, why did you just go ahead and type this out and amend your operating agreement? They just wrote it on the back of it. But cases where they actually confuse what in practice looks like just more contributions or investment, but they call loans, but there's no interest rate attached to it. There's no payment schedule attached to it. And that's another area that just seems ripe with the disagreement and fallout, because of course they like the idea of loans because they're supposed to be more secure in the sense that they get paid back, and they're not dependent on whether the company makes it or doesn't. They're owed one way or the other. So investors like that and the ability to get that back, but just confusing what is capital and what is a loan. Have you seen that same kind of thing?
Yeah, that happens all the time. So if it's going to be a member loan, it should have a rate of interest, and it should have a repayment schedule associated with it. I mean, that's what you expect and should have, if you're going to have a member loan. Otherwise, just call it a capital contribution. If it's going to stay in the company in perpetuity, and there's no requirement that it be repaid back at any given time, why do it? Instead, it should have a promissory note. You should have a promissory note with the traditional terms of, you know, uh, interest, payments, maturity date, like you would any other loan that's, being made to the company.
So another common type of business dispute that I know we see is wrongful conduct of another owner. How often do you see that? Maybe less often, but these disputes end up typically being pretty big.
Yeah, these are pretty big. And what I'm talking about, a couple of things. So the first type of wrongful conduct can be financial, where you have one owner that is basically using the company as their personal piggy bank. Um, Maybe they think it's okay, because they're just not, they don't have a certain level of business acumen, or they're not experienced. And so they think, oh yeah, I can use the business to, make my car payment and pay my mortgage. And because, I have meetings at my house. So why not? Right. Well, no, it doesn't operate. It doesn't work that way. Especially when you're in business with other people, right? You have to be financially responsible and use the company money for company purposes only, and not use them for, your own personal benefit. And then there's other times just outright theft, where, money is being skimmed off the top and embezzled and, um, stolen from the company. And, so that's one time. The second type of wrongful conduct is, one owner engaging in some form of activity that's going to cause a loss or damage to the company. A common example is sexual harassment. that they are dealing with employees of the opposite sex in such a way that is going to expose themselves and the company to liability. That would be, an example of wrongful conduct that needs to be handled and dealt with, but that could, give rise to a conflict because, if you're a business owner, you're saying, well, I don't want to be stripped of my duties, my power within the company, but yet the other owner is like, you can't be in this position because we don't trust that you're going to do the right thing.
Yeah. What about here's another one. This one might touch kind of close to home with real estate investors. This is wrongful conduct, no doubt, but oftentimes I think it probably falls in the category of negligence or gross negligence or somebody who's just a bad bookkeeper. But a real estate investment company doing multiple projects, and you run into this robbing Peter to pay Paul. Seems like we've seen that one over the years a lot.
Yeah, we've seen that quite a bit. Back in the day when the housing market crashed, 2008, 2009, we saw on construction projects where basically the contractor was, for lack of a better term, was engaging in a huge Ponzi scheme, right?
Mhm.
Would basically take money from one project to pay another project, and then they would have to land another project after that to pay the project that they were taking money from, and all the time they're skimming money off the top for quote unquote profit and their overhead and operating costs, and basically they were not breaking even, but nobody knew that because of the fact that as long as they could line up a new project and get money on that project, then they can afford to fund the other project, if you will. And that happens even in the real estate arena where um, maybe you're the more active owner. Your job is to oversee projects, and you mess up. You have a property that you're going to end up losing money on, and you're not comfortable going to, you know, your other owners or your partners and saying, "Hey, look, this one turned out bad." Um, and so you're not willing to have the tough conversation. And so instead of having the tough conversation, what do? You say, "Oh, let's invest in this other project. We need some funding." You get the funding from your other partners, and then you take that funding and you apply it to the other project so that it's at least break even, if not, if not, it looks a little profitable. Well, now you're back to that, scheme of, well, now I need to, make a lot of profit on this one, just to get on the new one, just to kind of be break even and that type of thing. Or I need to find another project. And then you're kind of stuck in a revolving cycle. So that does happen both on construction projects as well as investment properties.
Well, not being able to have a tough conversation segues into another type of common business dispute, which is just personality conflicts. Um, Having a hard time working with each other. We called this business divorce. It's a lot like marital divorce. Everything was great during the honeymoon phase, but in practice, it's just not working out. We disagree over management. Um, we disagree maybe just over everything, and that's just not because anybody's done anything wrong, because we have different personalities and we just don't work well together. Do you see that a lot?
Yeah, that's probably one of the biggest issues. Why do 50% of marriages end in divorce? Because they just didn't get along.
Yeah.
Nobody was, now granted, there are certain marriages that end badly and one party, did something wrong. But a lot of times it's just simply like neither party's really at fault. They just can't get along. They don't want to be married anymore. And so they decide to go their separate ways. Uh, in a business, think about it. You know, when you're in business with somebody, it's almost like, similar to a marriage relationship. If you're putting in full-time hours in a business, like you and I, when we started our law firm, right? We were working 10, 15-hour days, And, we had a real small office, and, we were right on top of each other, because that's the only space we could afford. Right.
Yeah.
And, we were down at the office all the time, probably working with each other and around each other more than we were around our spouses.
Yep.
And so if you don't have
Maybe that's why we're still married.
yeah, but if you don't have the right personality to mesh with somebody, it's not like somebody's doing something wrong.
Yeah.
But if you don't have the, personality to get along with somebody, and you're putting in that type of time, like at some point you're just like, this isn't working. Like, I can't work with you. We can't agree on decisions. And, I just, we're arguing all the time. And that type. And so you decide, well, that's just, I don't, like coming to work anymore because, uh, it's conflict all the time, and, there's disagreements, and, people's personalities just don't mesh well together. Now, you don't know that generally going in, although maybe you can tell. But just like with the marriage relationship, everything's great at the beginning, and you think, oh, we're going to be together forever. And then you get in, and you're like, oh, I can't live with this person. Right. And so you guys just go your separate way. That's the same with business owners. They just, they need to go their separate way. The problem is that business still has to operate.
Right.
It has to still function, or it's done. Like, or you just, let it go. Just like, there's certain, uh, we saw this, in the short sale days where, couples divorce, and what happens? It ends up in a foreclosure. The property ends because neither one of them wants to take responsibility for the property. And so they just let it go to foreclosure, versus maybe if they were married and still living there and, paying the mortgage, it wouldn't have happened. Same with the business. Like, you know, somebody still has to operate the business. It still has to function. Um, and if both sides can't agree who that's going to be, the business may not, may go under. And so, yeah, it's simply just personality conflicts where it's time to go our separate way. And then have to figure out, well, what does that look like?
Right. What about new unexpected partners or business owners as a result of the death of your previous partner?
Yeah, that's a major one. And we're going to talk about operating agreements a little later, and, what should be in the operating agreements to deal with that scenario. But, um, if your operating agreement isn't structured properly, then, what could happen is your, um, other owner or business partner dies, and their spouse comes in and takes over, or
Or their 18-year-old kid.
their 18-year-old kid. Yeah. Or maybe there's a divorce and the spouse is awarded a certain interest in the company. And all of a sudden now you're basically trying to operate a business with somebody that you don't know, you didn't agree to on the front end. And that could create and does cause, conflict, at times, which is why, and we'll talk about this later on, there should be certain levels of business succession planning in place to avoid that.
So those are the common types of business disagreements we see among partners. So let's talk about, given those disagreements within a business, how does that impact, or how can it impact the operations of a business?
Well, the first is deadlock, where basically, the disagreeing owners each own 50%, or maybe you have four owners, for example, and they all own the same percentage, and two are on one side and two are on the other, and they just don't get along. And because they don't get along, uh, they can't decide on anything. It could be, just a simple thing on, hey, we need a new copier, let's purchase a new copier. And they like, well, I want a Minolta and I want a, Canon, right? And it's like, just because, just because. Sometimes it's just because. And so you end up with deadlock. Well, if you're at 50-50, who decides? Nobody decides. You just don't get a copier, right? Either one side's going to give in, you don't get a new copy machine. Either one side's going to give in, or it's just not going to happen. And that's how deadlock works. If there's deadlock, you can't make a decision. The company can't do anything because, one side may vote against a decision just out of spite, you know? And so you have to somehow resolve that or get rid of the deadlock for the company to even do business.
Yeah. So, and a business at the end of the day is, on one hand, a legally recognized entity, but on another hand, a legal fiction, in that the law sees Fowler St. Clair PLLC as a person in the eyes of the law, but Fowler St. Clair can't talk outside of you and me talking for it. And when you've got multiple owners that have a say, and you haven't planned for that on the front end, and it's just an equal split, then you're no farther away than the first disagreement to hitting deadlock. And so you can see why that would be a quick area that can become an issue. And it starts with just the copy machine, like you said. But as we start talking about, and we're kind of assuming a universe of all these possible disagreements we've talked about, that universe of disagreements expands quickly in a dispute to the point where you really can't get agreement on anything. And if you don't have agreement on anything for that legal fiction entity, then that entity doesn't act, can't do anything. It can't uh, deposit money from the bank. It can't enter into contracts. It can't sell that real estate. So basically, that deadlock is everything, and planning for that essentially is everything. Now that just really applies to general operations of the business. Let's talk about how some of these disagreements, and we'll talk more about how you can fix the deadlock issue, but let's talk about how these disagreements can impact the buying and selling of real estate in a real estate, specifically a real estate investment type business.
So when the business is primarily involved in real estate, you have to analyze, like you said, who has the authority to act on behalf of the company? Because the company can't just magically show up and sign documents because, well, it's its own legal entity and it's deemed to be something separate and apart from its owners. It can only act through its representatives. And so whenever you're buying or selling real estate, whether the owners are uh, getting along or not, the title company or anyone else handling a real estate transaction is always asking the question, who has the ability to sign for the company? Who can sign this purchase contract? Who can sign this, warranty deed, this promissory note, this deed of trust, this lease? Who has the ability to sign? And depending on how the company is structured, it may be all owners have to sign, unless you have an operating agreement that specifies otherwise. For a limited liability company, it generally would be, the members are the ones that have to sign, absent a operating agreement that is to the contrary, or absent being a manager managed. If it's just a standard member managed LLC, then all members have to sign for the acquisition and disposition of real estate. And if that's the case, and you have one member that holds out because, they're disgruntled, you're not going to be able to do anything. You're stuck holding your real estate. You're stuck, not being able to lease your real estate. You're stuck not being able to purchase real estate. And once again, the operations of the company are going to come to a grinding halt.
And boy, given like market conditions now, grinding to a halt can have serious consequences, even if for 2 weeks, right? 2 weeks right now is an eternity in the real estate market. So let's talk about, given that we've got these disputes, common ways that the disputes are resolved with businesses, and how we see them do that. The first one, probably the most beneficial, the most recommended, if you can do it, are settlements, right? How does that work?
So settlements are basically the parties in the dispute coming together and agreeing on how to resolve it. An example, a very simple example could be you have owner A and owner B who can't get along. And so they go and they come together. Either they meet amongst themselves, their attorneys, uh, go back and forth or work with them, or they do, a mediation or a settlement conference or some alternative dispute resolution procedure. And they basically agree that, and this would be common, that basically one of the parties is bought out. There's some form of agreement to buy them out, for them to exit the company. And we call that an dissociation in Arizona. Other states may call it like a withdrawal, but they basically dissociate. One owner dissociates, basically gives the company over to the other owner, and then there's some agreement on payment or compensation to the owner that's dissociating or withdrawing from the company. So that would be one way, and that's probably the quickest way to resolve a dispute, is to try to come to some form of agreement to allow the company to continue to operate while one of the members exits from the company.
Now that can be mandated on the front end within an operating agreement, and some mediation provisions in agreement can actually be extremely lengthy, but it also can be voluntary, right? The parties can basically just agree to a process to try to get that done for the benefit of the company.
Yeah, so your operating agreement can say in there that the parties agree that any dispute that arises amongst them must first go to mediation, and then there's normally a procedure of um, whoever initiates it will select 3 potential mediators that can mediate it within, say, 10 days, and they submit that list to the other side. The other side then picks one of those 3 to mediate the dispute. That's kind of a standard mediation clause. And it says basically you have to do this and you have to go through this procedure before any lawsuit, any arbitration, anything is filed, which would be considered some type of litigation matter. So you have to go through mediation and try to resolve it. Alternatively, if you don't have an operating agreement that has that provision, then you can agree amongst yourselves that, hey, look, let's try to hire a mediator to come in and work with us to resolve this dispute. And frankly, I recommend that. I mean, if you have a business where the owners are not able to work together, but the business is a going concern and is, profitable, or at least, has potential, at that point, you should do a mediation, because that's in the benefit of the company. The company is going to benefit from that. It's not about the owner benefiting, it's about the company. And that's the other thing that I think when we talk about disputes, sometimes no party's right or no party's wrong. But disputes can be resolved if both parties recognize that it's not, when you're in business with somebody, it's not about you. It's not about the other person. It's not you versus them. You, as an owner of a company, are responsible to the company. You always, always should be looking out for the best interests of the company. That's part of being a business owner, is, you put yourself second to the company, not second to the other owner per se, although maybe you want to do that at times, but I'm not saying second to the other owner. I'm saying second to the company. Make the company your priority. Make the survival, the success, the profitability of the company your priority. And maybe that means you need to exit from the company, or maybe that means you need to buy the other owner's interest. But if both parties are looking at it from that perspective and going in and saying, as a business owner, my duty is not to me, my duty is not to the other member, my duty is to the company. What's in the best interest of the company? And if you go into any type of settlement conference or mediation with that approach, it should be resolved. And the company should survive with that approach.
Yeah, as you were saying that, I was thinking, boy, if that was the mindset of every business owner, mediation would be, a lock. We'd be able to get this done. The only reason we don't get mediations done usually, especially when you've got a third party there kind of explaining the thing, is just because somebody's position is rooted, in stone and they're not moving. Let's talk about a similar process, though slightly different, arbitration. Arbitration is another opportunity to resolve the disputes, and resolve them outside of court. Like mediation, it can be done and mandated contractually, though it doesn't have to be. Why don't you talk a little bit about that?
Yeah, so I kind of have a mixed emotions on arbitration.
Yeah.
So arbitration is basically a private resolution, a private lawsuit, if you will, to decide issues of law and fact. And so what you do is you hire an arbitrator. They're basically a private judge that the parties pay, and normally they have to equally pay the costs of the arbitrator, their hourly rate, and then the arbitrator um, holds a hearing, allows evidence to be submitted, then takes that evidence and makes a decision. Sometimes they'll decide motions. I mean, it's basically like you're in a lawsuit, but instead of going through the court system with uh, judges that are paid by the government and the parties aren't having to pay them, you're hiring somebody privately who's going to oversee the process and make a final and binding decision. And like you said, it can be contractually mandated or it can be voluntarily agreed to by the party. So if it's contractually mandated, what that will mean is the operating agreement will say that the parties, that the owners, the members, and the company agree that any dispute that's not settled by mediation, because normally you're going to have a mediation provision in conjunction with your arbitration provision, anything that's not resolved by mediation must be resolved through binding arbitration. And then there's a process for appointing an arbitrator. Sometimes you just open an arbitration with the American Arbitration Association, and then they appoint an arbitrator and they handle all of the processing of the case and the filing of motions and uh, the applications and responses and that type of thing. Or if you don't have that in your operating agreement, but the parties are like, hey, we don't want to go air our dirty laundry out in court, let's just hire somebody because it will be faster and quicker. And arbitration will be, right? It will be, because that attorney, uh, they don't have hundreds of cases. They may have one or two cases at any given time. And so you're going to receive their full attention and they'll be able to handle it in a more expedited basis. And so maybe the company will benefit from an arbitration, because the sooner the conflict is resolved, the sooner the company can just go about its business and continue to operate without issue. So the parties can agree, the owners can come together and say, yeah, we're going to do arbitration. Here's who we're going to use, or we're going to use the American Arbitration Association, and they'll appoint an arbitrator for us from one of their commercial dispute panels or business dispute panels, and they'll appoint somebody, and then they'll just process the matter and come to a resolution.
And I guess the one downside, well, maybe not the only downside to all that, is that that fast resolution and expertise in a judge comes at a high cost, or a significantly higher cost than what you're getting with a judge at least here in Arizona with the Superior Court. It's a public servant, an officer of the court that is paid, but you're not paying for immediately. So let's talk about that. Another way to resolve your disputes is through the courts, through a lawsuit. And I know that can take a variety of different forms and character, largely depending on the type of relief that a party's seeking, from injunctions to receiverships, dissolution of the company. Why don't you talk a little bit about some of those options and what they look like?
Yeah. So one option could be just simply filing a lawsuit for damages. Say, hey, look, I am an owner of this company. I'm filing on my own behalf, or I'm filing what they call derivatively on behalf of the company. So the company's been wronged by this other owner. Maybe they've embezzled, stolen money, whatever the case may be. So the company has a right to be repaid the amount that's been taken. And so what you're doing is you're going to pursue damages against the other owner. Or maybe the company's in a deadlock, and they're not going to be able. The only way for it to survive is if it starts and continues to conduct business. Well, in that case, you have a right to appoint a receiver, which is basically a third party appointed by the court to step in and run the company, and they make all the decisions. There's really little to no input by the owners who are in the dispute over the operations of the company. The receiver is going to come in, and the receiver is going to do what the receiver deems best in the interest of the company, not in the interest of the owners, but in the interest of the company. And so you appoint that receiver, and the court appoints the receiver. They take over, and they have the full power to basically operate, run the company, enter into contracts on behalf of the company, sell property on behalf of the company, buy property, open bank accounts on behalf of the company, borrow money on behalf of the company. They basically have the full weight of authority to, manage and operate and run the company.
And they don't work for free, do they?
No, they don't. And they charge, generally they bill hourly. Now, the first way that they're compensated is from the company. So if the company was profitable, or they're able to turn it around and it becomes profitable, then they're paid. If the company doesn't pay, then the party that appoints them is responsible for paying their fees and their costs. And so
be careful what you wish for.
Be careful what you wish for. Yeah. So that's another thing that you can pursue, or remedy you can pursue by filing a lawsuit. The next is a dissolution. So you can go and say, hey, look, judge, we're fighting. We have deadlock. Company's not doing well because of it. I don't think the company is going to survive. Let's just sell off all of the assets. Let's dissolve the company. I'll take my share. The other owner takes their share. And from there, the company just stops operating and it's liquidated.
So let's talk about how to avoid some of these issues. And I'm going to assume for this discussion that you're dealing, or that the common real estate investor out there is dealing with a limited liability company, because that's probably 85-90% of the companies out there that do this kind of work. But assuming that's the case, doesn't this really start and end with your formation documents, mainly your operating agreement?
Yeah, it starts with the operating agreement, but it does not end with the operating agreement. So an operating agreement is recommended, but not required. So here in Arizona, and most states have it, is the Limited Liability Company Act is what we have. It's a scheme of statutes in Arizona that basically say, hey, if the company doesn't have an operating agreement, our statutes are going to fill in the gap. But they're very skeletal, right? They're just enough for the company to operate, not really much more than that. So if it's a single member LLC and you are the company, basically, obviously you're going to want to keep corporate formalities and stuff to maintain that corporate veil. But if it's just you, then the statutes are fine because you're the ultimate decision maker. You can do what you choose with your company. But if you're in business with somebody else, then in that case, you should have an operating agreement that's going to basically define your relationship. And there's some key provisions that you're going to want in that operating agreement that will hopefully, assist with resolving some of those conflicts. So the first thing is to provide that any party that's going to take over a member's ownership interest in the company is only an assignee of that membership interest. And so what that means is if I own an LLC and I were to die and my heirs then inherit my membership interest, that they're only an assignee of that membership interest, which means they only have the ability to receive and share in the profit and losses of the company. They do not have the ability to engage in the management of the company. They do not have the ability to vote within the company, and they have very limited access to financial information of the company. Basically, they have a right to enough financial information to establish whether or not they're properly receiving distributions from the company, the profit distributions. That's the scope of the financial information that they're entitled to receive. The second thing that you're going to want in there is, and this is kind of a balancing act, But you're going to maybe want a provision in there that says that, there's a manager or a managing member, or one member can basically continue to operate the company. Um, and that way the company can operate if there is a dispute. And, you know, you as the other member, if you give a member that interest and you're not that authority and you're not the one taking it, you may not like that, but at least the company can continue to operate. And then you can pursue your other remedies in court and that type of thing. But the company is still able to operate if one member is considered the managing member, or you form a manager managed company with one member being the manager and able to basically operate the company without involvement of the other owner who you may be in a dispute with. We've already talked about this alternative dispute resolution procedure. So, a mediation provision, an arbitration provision. And then finally, you're going to want to establish, and this gets back to what I was saying before, that your priority as an owner of the company is to make sure that the company is successful. Your priority is the company. It's not you. It's not your interest. You need to always be looking out for the interests of the company. And so you're going to want to put in the operating agreement fiduciary responsibilities of the member to the company, basically saying you are a fiduciary of the company and your job is to basically look out for the company, not for your own interests, but for the company's interest. And you're supposed to always do what's in the best interests of the company, even if that means that it's not always great for you.
Right. What about another agreement that is, I think, often overlooked, usually at the forefront because new business owners are typically trying to save money and don't want to spend money on lawyers to do this, but the buy-sell agreement, and how can that help?
And that's why I say that the operating agreement is not the end. It's the start. It's the beginning, but it's not the end. Really, a buy sale is the most important document for a company to resolve and avoid conflict. But unfortunately, like you said, a lot of new business owners don't put a buy sell in place because it costs more money. It's a complicated document. And so, from a legal perspective and legal work perspective, um, there's going to be an additional cost beyond the operating agreement to put a buy sell in place. So most, uh, new business owners like, oh, we're going to get along. Why do we need a buy sell? Right? Just like, it's the honeymoon, right?
We're
Like,
young, nobody's gonna
yeah,
die.
nobody's going to die. We're not going to have a conflict. We've agreed on everything so far. We like each other. This thing's going to be the greatest, business in the world, and we're going to get along. We're going to make all this money. You know, no, there's no need to spend extra money on a buy sell. And then, of course, you know, it's always the look back and like, I wish we had the buy sell. So basically, what a buy sell does is it has certain triggering events that provide for the purchase of an owner's interest in the property. It allows basically the company to buy out one or more of its owners depending on certain events. And those events are, so the first one is a voluntary dissociation or withdrawal. And that's basically where one owner says, hey, I no longer want to be part of this company. I'm ready to move on. I have another business venture. Um, my life circumstances have changed. Maybe my geography has changed. I'm moving. I want to move somewhere else. I don't want to stay in this location. And, to really be a business owner in the company and be productive, I have to be in this locale and I want to move. So I just don't want to be involved anymore. And so there's a provision in there of how that member is bought out. A dissociation for cause is another thing you see in a buy sell, which is, um, a member has embezzled money from the company or is acting in a way that's putting the company at risk of liability. And so the company has the right to basically declare a for cause withdrawal or a for cause dissociation. Then there's provisions in there on how the company buys that out. The other is a member elected or voted dissociation. So if you have two business owners, you may provide that one of those owners has the power basically to say, hey, uh, I don't want to be in business anymore. And so I'm going to, have the company buy you out. And maybe there's another provision that gives that other owner the right of first refusal to say, okay, you're going to buy me out for this amount of money. I'll return the favor and I'll buy you out, if you will, right? If you think that that's good enough for me to be bought out, then I have a right to then buy you out. And that's a common provision where there's a check and balance, meaning if I want, you out of the company because we just can't get along, so I propose that I'm going to buy you out for this amount of money, and I think it's fair. Well, I have to be comfortable with the fact that you might turn around and say, okay, I think that's a good deal for me to buy you out. And then you have a right to buy me out, but somebody's buying somebody out and the company's going to operate, and going to continue as a going concern. The other is death. And so one member dies. What does that look like? Well, a smart business will put key man life insurance in place, which basically states that if one of the owners dies, then you have this life insurance that is there that can be utilized to infuse capital into the company, as well as at the same time purchase the member's interest. So you have money that's going right away to the heirs to purchase their membership interest. Disability, that's another triggering event. And the same thing there, you can have disability insurance that provides that if a member becomes disabled, and there's definitions of what disability would mean. If a member becomes disabled, then there's insurance in place that infuses capital into the company so that they can find a replacement for that member. But at the same time, part of that insurance can go to that member to basically take care of them while they're disabled. And then finally, there's a divorce. If one member is going to divorce and that's going to impact the company, and there's going to be an amount of a membership interest that's awarded to the spouse, the member's spouse, well, you can have a provision in there that says that the company can just buy out both of them. And so you have a circumstance that deals with divorce. So you have these triggering events which allow basically the members to separate. It's almost like a premarital agreement, right? Or a prenuptial agreement. You have these events that say, okay, well, we can separate at any point and the company can still continue to operate. And that's the advantage of a buy-sell, and that's basically what a buy-sell is.
Well, and the beauty is everybody's not left holding the bag wondering what we're supposed to do, so I guess we'll just fight over it. It's already been pre-planned. Here's what you're going to do. If it's done right, it's funded with insurance and everything else, and really the best practice to do it. With that, everybody, that is our episode today. Thank you for joining us. We appreciate it, and we look forward to seeing y'all next week. Have a good week.
Have a good day, everyone.